Hi, everyone. I'm going to just start again so that we've got the recording. So I'm Sean Rehag. I'm the director of the Center for Refugee Studies, and I'm a faculty member at Osgoode Hall Law School. I'm delighted to welcome you all to our dual book launch. It's exciting to see that we've got a couple of great books to hear about today. What we're going to be doing is that our speaker today is going to be introducing these two books. Then we're going to have an opportunity to have a bit of a discussion. And I connected with the speaker just before the meeting. She's expecting to speak for about 20 to 25 minutes. So if you're wanting to know how things are going to go, that's what we are currently anticipating. So I'd like to introduce our speaker, who is a colleague of mine at York University, Nergis Canefe. She is, as I suspect that most of you know, a scholar of public international law. She has an interest in comparative politics. She's an expert in forced migration and critical human rights. And she's held a number of prestigious positions both here in Canada and in Europe, including in Turkey. Her books that she's going to speak with us about today, I'm not sure what's going on with that share screen, but I'm going to stop it. Sorry about that. So the books that she's going to be speaking about today engage with the areas of specialization that I just mentioned. The first book is called Transitional Justice and Forced Migration, Critical Perspectives from the Global South, which was just published in 2019 by Cambridge University Press. And we are going to provide links in the chat, so you can keep an eye on the chat, and you'll find links if you'd like to order the book. The other book that we'll be hearing about is Crimes Against Humanity, The Limits of Universal Jurisdiction in the Global South, which is forthcoming later this year. You can actually now pre-order it as of, I think, yesterday. And we will circulate the link about how to do that as well. Then the last thing that I wanted to say before I hand things off to Nergis is that while Nergis is speaking, we will do a little contest in the chat. So there'll be a question in the chat, and the first person to accurately answer the question will get a free copy of the Transitional Justice and Forced Migration book provided by CRS. So keep your eyes on the chat, and you can participate in that contest. So that's it for me for now. I'm going to hand things over to Nergis.
Thank you, Sean. It's a great pleasure to be here, and and there couldn't have been a better and more appropriate host for these book launches, actually, because both of the books were written under the aegis of CRS, and each of them in their acknowledgement section have a long list of names who are affiliated with CRS, who were at the helm of CRS, and so I feel very much at home holding the book launches here. The reason why there are two back-to-back, the Cambridge one came out at the end of 2019 after a very lengthy process, which was somewhat marred by my illness and extended periods of treatment. And then the Crimes Against Humanity is literally just entering print right now. And these two are actually complementary aspects of a much larger project, which is so to speak, an interface between forced migration studies and especially international human rights and international criminal law. So what I want to talk about is, obviously, I'm not going to bore our esteemed audience with summaries of what's inside, but I want to tell a few stories about how these things transpired and hopefully where they could be put to use, because these are projects, and I am constantly self-revising, and I'm constantly finding different entry points, multiple entry points to similar subjects, and I would say over the last 30 years. So these two books actually mark the last 10 years of my scholarly career, in addition to some of the smaller articles and projects and whatnot. And then the next 10 hopefully will be complementary to what has been covered in these, but push them in the area of both ethics of doing work with war crimes and forced migration and human vulnerabilities, as well as widespread presence and conundrums of statelessness in terms of its conjunction with forced migration. So that's the kind of future trajectory that's happening right now. In terms of the books, the first one, The Transitional Justice and Forced Migration, is actually dedicated to late Barbara Harrell Bond. And we had multiple discussions with her as I was pulling the team together who contributed to the book. The second one is actually dedicated to Howard Edelman, who was very critical of the project at the beginning, and yet grew kind of warmer towards it as I came to complete the manuscript. And then the second one, as I'll come into in a minute, also owes a lot to a whole cohort of Osgood faculty who had the patience to listen to my outrageous ideas and then kind of transgressing fields and creating a new collage of how to put together political philosophy, legal theory, and comparative studies of forced migration. So in terms of transitional justice and forced migration, the volume itself is, I don't think I should take too much credit, in the sense that indeed I brought the team together and then we got together in a number of occasions where we exchanged ideas. So the tone of the voice, as my editor at Cambridge said, is quite strong, because I wanted to do something that was controversial, in the sense that I didn't want it to fit into the the larger vein of transitional justice debates, and then there were beautiful pieces on that, not because I was against everything that was said, but because I felt like there were certain kinds of voices that were missing from the debate, other than being published as short journal articles. So I brought together a very strong body of writers and scholars who were known, all of them in the Global South, in terms of their decades-long work. So for instance, Ranabri Samadar from CRG from Calcutta, Turgut Tarhanlı from Istanbul, who was the dean of the Bilgi Law School for almost a decade and who runs and established the Human Rights Law Center there. Marisa Ensor, who's quite a well-known name in terms of transitional justice and displacement of youth. And we have a number of other people, such as Fabio Pabon, who was quite influential in the Colombia negotiations, Jessica Chandrasekhar, who was an Osgood graduate and who knew quite well the inside of the Sri Lankan Tamil conflict. Shamaran Mako and Hannibal Travis were very well-known scholars that look at minorities in the Middle East and the right of return in Iraq. Galia Benarie, who did a lot of work in the African and Latin American context concerning testimony and sexual violence, so on and so forth. And then we, of course, had Helen Hingens and Jackson Oldong, who looked at the Great Lakes region in terms of victim reparations and legal justice, as well as Lami Bertan Topuzlu and Nasrin Chowdhury and Shamna Tachampoya. So this was quite an impressive group. And I must say, I learned a lot as I received the chapters and read them in detail. And what I did was, when I put them together, we actually wrote an introduction to the book, which itself was quite a manifesto, saying that this is the way things have been done in the nexus of transitional justice and forced migration. And if you wanted to introduce new questions to this debate, then you've got to start somewhere else. You've got to start in a historically contextualized framework. And both legal questions and political questions have to be addressed from within. That was the tenor of the book and then all the different articles, in total 11 of them. And I already have been receiving feedback from different audiences saying that this is very unusual, and then they're finding it quite helpful in the sense that especially constituencies dealing with forced migration and international law and all political transformation rhetoric, if they need a different entry point to the theoretical debates and larger questions, it seems that this volume might be a good starting point. So how did we end the book? I mean, it was quite interesting to actually write the introduction to the book, which I said was in the form of a manifesto, more or less. And then I had to put together concluding remarks, which were indicating in terms of where do we go from here. So in that sense, I didn't have answers so much as I had more questions concerning the transitional justice, great transformation, so to speak, mass upheaval, mass political violence, and forced migration nexus. And I think in that sense, the second volume itself might have been, it could be regarded as a continuation of a similar debate. And second volume itself went through several reiterations as I was writing it, and it grew in size. And then when it came to the publication stage, it got cut in half. So the actual manuscript was twice the size of this, and now it's much more sizable. And that enlarging and shrinking process itself taught me a lot in terms of what would be succinct for delivering this kind of message concerning politics of international law in the global south, in particular as it applies to mass political crimes and the category of crimes against humanity and war crimes, and what is, how shall we say, additional. It's an addendum. It doesn't have to be there. So I think this is my 6th or 7th book, and then I'm learning better with each round of writing how to cut the excess, and I'm learning to really respect economy of words. And it might go against certain tenets of scholarship in the sense that, of course, you do need to be very clear about your references and in your audience and whatnot. But I'm learning that with each project that I'm spending 4 or 5 years, sometimes this one actually spend a whole time period of 10 years. When I come to an end point, the more clear I am, in effect, the less I have to say. I don't have to qualify each statement above and beyond what is really fundamental in terms of its content. So this second volume, which is literally going in print right now, discusses universal jurisdiction, crimes against humanity and war crimes from the lens of third world approaches to international law and radical pluralism. And it questions the concept of complementarity in terms of large international legal institutions such as International Criminal Court as they are perceived in the global south. And I think the most important contribution it makes, and that's what I have been told by the reviewers as well, is fair enough, it's a tidy debate, it's a nicely put together text if you're interested in the history of crimes against humanity, both from a doctrinal perspective, but also in terms of its applications post-Second World War. It has a whole chapter on collective responsibility / societal wrongdoing. And it tries to put together arguments about legal judgment that are used in criminal law context and moral responsibility for mass atrocity and mass political crimes. And it also pushes the envelope in terms of how do we define legal accountability, how do we attend to regimes of accountability in international criminal law, and what are the limits of transnational law as far as state criminality is concerned. And the overlap between the first one and the second one, as well as my overall scholarly portfolio, is that it looks at state criminality as well as mass atrocity, and it looks at excesses. And then the most outrageous expression of these excesses is obviously the exiled populations who are subjects of forced migration with no right of return. And so there's a whole section there that looks at the impossibility of testimony and witnessing to these mass political crimes, especially if you've been surged, if not entirely cleansed or killed. And therefore, the remaining account of what has happened and the accountability regime that follows after that tends to be very limited in its nature. And it needs to be much more historically rooted to attend to organized political violence in the context of not just the global north, but also in the global south and post-colonial society. So there is a section there which looks at absorption of international criminal law jurisdiction concerning crimes against humanity. And I'm not saying anything all that new about hybrid courts, but I think what I'm adding to the conversation is that hybrid courts is one expression of the possibilities of local absorption and rejuvenation of a certain discourse, legal and societal, against state criminality. So I'm actually sitting on the fence, and this was a very difficult piece to write, because on the one hand, international criminal law scholarship is very much against these centrifugal dictations of international criminal law. But on the other hand, having worked in the global south almost my entire life, I do know that we do need these regulations, and we do need certain components of international criminal law so that we can actually turn to states and organize political bodies and seek accountability in the long run for mass crimes. So it was a very difficult piece to write, and I remember at one point really feeling that I wanted to seek refuge from this list of carnages of humanity that we do to each other, north, south, 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 from within, because night after night, month after month, I was reading the court documents about these very heinous crimes, and then the internal perception, and then I was looking at the deciphering of these same events by local NGOs and human rights groups and survivors groups. And at one point, I remember going to Istanbul and having a discussion with one of my colleagues, and I said to him, I can't write this. I'm just so demoralized after doing this work for 5 years. And he said to me, welcome among us. This is what your job is. You will pass that stage, and then you will feel at home there. And it's not a nice place to be, but some of us has to do it. And it's not about being chosen or being more brave, but it's just about really staying with it and keep discussing it, keep making it visible, audible. And in terms of what we call in the legal parlance, fragmented legal regimes, regional adjudication mechanisms, hybrid jurisprudence, all this language may be familiar to some and not so familiar to others. I really believe that they have currency above and beyond what we write academically. They really do correspond to realities on the ground. And therefore, it's almost like we perform a bridging act. It's almost like we're messengers, so to speak, who can speak both languages, we can understand and speak the language of society, especially the victims, as much as possible with responsibility. But we can also understand and speak the language of knowledge production and knowledge mobilization. So one of the tenets of my efforts in terms of putting both books together, one is a teamwork, although I kept pushing in a certain direction and my co-authors really obliged. And then the other is my own journey to international criminal law jurisprudence. Both of them, I think, are efforts to bring what's considered the outside world into academia, but also some of the academic and scholarly knowledge to the field as I'm working with groups in different jurisdictions. So in terms of the contents of the second one, the crimes against humanity, I just want to share with you, and this will be kind of wrapping up what I'm saying here, and then hopefully we'll open it up for discussion. First of all, some of you know that I draw, and I draw on walls actually. I'm not good on paper, but the cover of the Transitional Justice is something that is created on paper, and it was actually created for Galia, for her center at the time, so that when you enter the center, who deals with very gruesome subject, you had an aesthetic call to what they were dealing with, and it was part of a series. So the cover is made by me. The second one, I'm not sure whether I can actually find the image here, but there is a Tree of Life that is my version of Tree of Life, that the publisher actually agreed to incorporate into the text. And you must understand, this is a series on international law, in particular international criminal law. So that was quite a negotiation. But they saw the merit when I gave the justification of why that drawing should be there, because the idea is that the entire system, it's both fragmented, but it's also in so many ways feeding from each other, both equalities and also potential wisdom and vision towards the future. So the other thing I want to talk about is the contents of the second one. And I must say, I really exercised courage in terms of saying things in the language that I want to say things. And I think sometimes people are lucky to do that in early stages of their career and then establish their own language. But for most of us, and certainly English is my second, if not third language, most of us, that courage comes later on because you're using another medium and you're thinking sometimes in multiple languages. So for instance, the first section starts as topographies of universal jurisdiction and international law. And then there are some interesting twists and turns in terms of the terminology I used. And I went to Latin phrases, and you might say, you know, legal scholarship, of course you're going to use Latin, but not in the way I did, I think, for the most part, because I really went to ancient Greek and Roman legal philosophy, not because I'm prioritizing them per se, but I noticed as I read Seneca and as I read some of the other thinkers who look at, let's say, collective guilt, some of the questions I was asking, they have been there since time immemorial. So the most important portion of the work, as far as I'm concerned, it's on societal wrongdoing and legal judgment and responsibility, for instance, is titled Mea culpa, sua culpa, tua maxima culpa. And those of you who understand this, it's about you know, you being guilty, me being guilty, but all of us being actually the most guilty. And then that refers to a very different approach to legal accountability regimes for mass crimes beyond the Eichmann trial. And I also pull in the debate from Arendt Jasper's confrontation about the necessity of judgment. And I propose an engaged theory of legal judgment that has that extended discussion leading into transitional justice. So to wrap it all up together, it's almost like, although the first volume was on transitional justice and forced migration and perspectives from the global south, the second volume is crimes against humanity, mass crimes, among which there's a significant proportion of societal criminal activity that leads to forced migration. And the second volume leads you towards the inefficiencies of a solely legal approach to such crimes. And then it leads the discussion into transitional justice with highlight on forced migration. So like, it's almost like a circle completing. And for those of you who have children or accustomed to this model, there's a spiral learning model in the Montessori education system. And so what that means is, you know, you do the full circle and then you revisit it, but you add things and then again and again. And so I think this is what's happening with me. I'm starting from one point, and not just now. I think since I was perhaps 20, I'm obsessed with certain kinds of societal and state criminality. And what happens when these crimes take place, and what happens when we normalize them? What happens when we forget them? What happens when people are exiled and never return? And these questions remain with me. And I'm seeing every 10 years, I'm revisiting them, but from a different angle. And I'm hoping with each revisitation, the discourse that I'm able to offer and share with my audience and with my students and with my colleagues gets richer and denser. And hopefully it has some components that adds to the ongoing conversation that has been going on for a very long while. So on that note, I'm going to end the presentation and perhaps open the floor.
Thank you so much, Nergis. Before we get to the questions from the audience, I did want to say a couple of things. So the first thing I wanted to say is, for those of you who are following in the chat, we do have 2 winners of the contest that we ran. So the
One of
first
them is a
winner.
student of mine, actually. That's wonderful.
So we've got Stefatula and Anusha, who will be receiving a copy of the Transitional Justice and Forced Migration text. So congrats to both of you. I also received some news in the chat that I was not aware of, which is that I understand that it's Nergis's birthday today. Is that right?
Yeah, it is. Yeah.
So happy birthday from all of us. We're delighted that you're sharing your birthday with us today. We're the ones who get the gift here. So
I am very, very happy. This is the best way to
thank
share
you for that. Okay, so why don't we open things up to questions? I suggest you use the raise hand function just so that we can keep everything, so that I can keep a speakers list. So who wants to ask the first question? Having some Zoom silence here. Give you another second to think about a question. Well, maybe I'll get us started. So I was interested in the question of, if you are going to be engaging with perspectives from the global South, how do you decide which kind of legal sources and which legal traditions you're going to ground? And did you struggle with that as you were putting together, especially the second book?
Right. I mean, I am a trailer, if that's the term, and you're familiar with us from Oslo. But there are at least 3 generations of trailers. So it's Turbo approaches to international law, critical approaches to international law. But at the same time, because I'm not a practicing lawyer, my approach to Whale scholarship has certain edges, which might be considered as unusual because I'm also trained as a historian and a history of ideas person. I have 2 PhDs. So a PhD doesn't mean anything on its own. It just means that you are exposed to different disciplines and different ways of handling things. So when I was writing the second one, I felt I was in the company of a great many, but I was also very alone, in the sense that I wasn't just creating a different version of the 12 scholarship looking at crimes against humanity. I was also trying to produce something that was practically, how shall we say, it has practical purchase. So one of the things about the hybrid courts was that they're mushrooming everywhere, and there are 2 kinds of opinion about them. One is they buy time and they really don't deliver justice in any meaningful sense. And that is actually a testimony to the failure of international criminal law in general. That's one reading that's possible. Actually, there are 3 readings. Another is that they are an extension of the imposition of international criminal law from the global north to the global south. But a third reading, which I encountered, which really raised my curiosity further and further, especially, and I started reading testimonies in the courts and amicus curiae by leading human rights advocates in these cases, was that they were that third space. They were that other place where you had international and local judges, where you had a certain criteria being determined by domestic jurisprudence, and therefore it wasn't seen as an imposition per se, where, let's say, 2, 3, 4 decades of human rights struggles and political struggles were finally finding some legal articulation within the domestic sphere itself. And then they were therefore seen sometimes as a force that was more congenial to a deep-rooted transformation, as opposed to having a hearing in The Hague. And so that's that third literature, which really made me struggle a lot, because the mainstream global north critical take on international criminal law is, for lack of a better word, it's imperial bullshit. The beginnings are skewed, the way it's structured, and I'm not denying any of that, but at the same time, you're dealing with mass atrocities and injustices, and you're dealing with real human lives, and you're dealing with societal conundrums that extend themselves from generation to generation, and there's got to be some addressing of them from within. And since many of these states have fairly heavy-handed histories of dictatorships and authoritarian regimes, sometimes you have to reach out to get that language. And then I I remember 2 summers looking at, there's a kit that ICC produced some years back about the local adaptations of Rome Statute. And there are country-specific versions of that. And I'm not just talking about adopting it through your parliament to your criminal code, which Canada has done as well. But I'm talking about, the different articulations and renditions of state criminality. And that was fascinating for me, because it was challenging the mainstream critical rhetoric as well. It wasn't that it was utterly useless. It was something else entirely. And I'm not quite sure what that something else entirely is yet. But I feel that it's a good place for me to be, because I have so many things I don't know. And I feel like it's just the beginning of a much longer journey. And then the more I learn, the more perhaps I can actually ask the right questions. All I knew is the critical approaches to international law was a good beginning point, but it brought me somewhere else, which is not all that common in the global north. Global north scholarship, and please forgive me, my colleagues are here who do wonderful trail work, is very much kind of focused on, what the global north did do wrong, and which is fair. And I feel like, okay, I'm someone who is operating in both spheres, and I know the histories of wrongfulness. But what I really need right now is, what can you take away from that, and what can you put to use when you have mass criminality, and then that repeats itself again and again from within the societies, a new hybrid, a genuine and authentically resonating code of conduct and societal responsibility. And that's why it was also very difficult to bridge transitional justice measures, which are soft law at best, with international criminal jurisprudence, which is very exacting, right? So the 2 languages don't always mesh together. So I don't know whether I answered your question, but.
No, that's great. Thank you. So are there other questions?
Hi, Sean.
Hey, Amar.
Hi. So can you hear me okay?
Yep.
Hi, happy birthday, Nergis. I'm sorry to be a floating voice here. I'm caught in that learning spiral right now. It feels like a different shape. But I just wanted to say, I look forward to looking at the final the books and everything. And I just wanted to pick up on that one aspect and maybe related to something in your introduction, which was this kind of divide between groups on the ground and also what you find to be practical or what might be more practical in the South versus sort of northern standing critiques. and how, how you see, like, what kind of different, maybe new problems the practical approach is productive of. In a different context here, in like critical legal studies and critical race theory,
Right.
there's always this choice between, the liberal law, the critical race critique, something in the middle. But it often can, create sort of new mischief. And so have you kind of seen that in the quest for intergenerational accountability for mass atrocity? Have you seen that playing out at all?
To a certain degree, yes. And I mean, what caught my attention was, let's say I was reading case notes from Yemen, or Israeli war crimes debates, or issues concerning atrocities against Kurdish population, and the different sources you would read. And if you only took the legal angle, you would just read like higher judgments, Superior Court judgments, European Human Rights Court judgments in that case. But I wanted to balance my reading with what was coming from the NGOs and INGOs, and then also there were a number of groups on the ground when I was writing the treaties who were reporting from Syria. And they were using the international criminal law language as an outcry, saying some horrendous things are happening here. If you listen, they actually fit into crimes against humanity and war crimes squarely, right? So and then they were given like descriptions of what was happening, and I thought, this is so interesting. This is like a tiny little group, and this information is not reaching anywhere. Similarly, what was coming out of Yemen. So they were wording what was happening in terms of state criminality in a language that would have carried weight if it was to enter international criminal law discussions, but it wasn't entering it. And they weren't expecting that either. I mean, that language was not used against the background of an international audience. It was actually used for internal consumption. And then I see that in the Middle East a lot. When it's used, it's not for the powers that be. It's for the people to understand that what's happening is not acceptable. And so it's almost used as a tool, as a discourse. And so I feel, and I mean, we had these discussions, Amar, with our reading groups as well at Osgood. I feel that the way we look at international law, especially international criminal law and then maybe refugee law, in the global north, from the top with a bird's eye view is very essential. But I think there's another story going on in terms of its utilization and instrumental application on the spot. And it's not that the people who are using this rhetoric are not aware of its imperial history or the power imbalances. On the contrary, they're very, very aware. But it's a different kind of political performance. And that's where I wanted to go methodically. What is it that they're hitting for? They're hitting for some sort of a genuine sense of seeking justice, especially in terms of multi-generational injustices. And the only language that they can use has to be above and beyond state sovereignty. And for that, international criminal jurisprudence actually offers some possibilities. You don't necessarily need to agree with the structure of the history, but the kinds of crimes that are described there and articulated and rendered as justiciable, they really have currency when these things are happening on the spot. And how they are becoming justiciable is a question for that society. And then that's a part of the debate we are really preoccupied up here in the north, because that's when all these interventions take place. That's when we see the neocolonialism. That's when we see the imposition. But when it's happening on the ground, in order for you to name the atrocity, you grab onto that language with full knowledge that this is internationally coded. And so it's like an entry to a different kind of discussion. So I mean, I'm still not at the shore. I'm still out there in the sea, but I think I'm a little closer in terms of having some sort of a sense of what's happening with the appropriations of international criminal jurisprudence.
Thank you.
Are there any other questions?
I mean, I don't know how to do this, but these books are published unless you're a very well-known author who is guaranteed to sell thousands in England. Then they're published in hard copy, and then so they're of the price that can only be purchased by libraries or major institutions. They're not published in softback, a paperback, right? And for classroom use, there's an e-version. And this is a question for Sean and Amar and other legal scholars among us, as well as other people who are attending kindly. I just wonder how we can actually make these debates more vernacular. Is that a wrongful outcry on my part? Because I feel like we're just talking to each other, and these are not things we should just be talking to each other about.
Yeah, I mean, I think that's a really important question. I mean, I think there's kind of a practical set of questions about how is scholarship produced and circulated, and how does the industry work? I know that CRS is very interested in thinking about how do we publish in a way that will be more accessible, especially to scholars in the global south for whom the cost of these things is maybe prohibitive. I see Susan McGrath is on the call here today, and she has some expertise in thinking through that question with some work that she did here at CRS. So I think there's that question, but I think you're pointing to something broader, which is, how do we make sure not just that our work is accessible to other scholars, but that it's reaching beyond that it's reaching beyond that it's reaching to the broader public, that it's reaching to important civil society actors, to government actors, and that's a challenging it's a challenging question, and I think all of us have different answers to that question. Personally, I do try to publish, and I do try to reach out into kind of newspapers, and I do try to give presentations not just in scholarly venues, but also in events organized by non-governmental organizations and community-based organizations. I think that works to a certain extent. It's still limited, though. I think my own scholarship could be quite easily critiqued for kind of selectively engaging with groups in the global north rather than groups in the global south. So I think what you're suggesting is a call for all of us to think more carefully about how we engage more broadly. But if anyone else on the call has thoughts about how to do that, I think we'd all be interested in hearing.
I mean, this is a very helpful answer, Sean. And I just want to say that you working on the global north has initiated so much change, and one doesn't have to geographically, obligate to work in this or that place. I think where we are most engaged and where we can transpire most effective change is where we invest ourselves. So I mean, especially with the book on transitional justice and forced migration, some of the scholars who wrote there were situated in the global north. So those boundaries are flexible, and we learn from each other so much. And I do work in the Canadian context about Muslim minorities. I did that for decades. And so it overflows, but you're absolutely right. There has to be other interfaces in terms of sharing what we know, and then the kind of expertise. Otherwise, it remains in the academia only.
I see that Tyler has a question.
Oh, Dina can go first.
Sorry, I just don't know how to raise my hand. No, go ahead. I'll wait. I guess I'll do this.
So I also wanted to thank you, Professor Canefe. It was really interesting to hear you outline your book, and the book sounds really wonderful itself. I also like my question, I wanted to start off by saying that I was really happy and in fact really relieved to hear that a more senior scholar found it pertinent to engage in a sort of like etymological and linguistic or historical sort of method that finds that these sort of the tensions in a certain way of approaching language, the kinds of questions that might be posed are ones that can like connect a very large sort of discussion that takes place. I was hoping you might speak further about the sort of possibilities and difficulties that you found while navigating these kinds of like linguistic explorations. Are you talking about the Roman context versus the English context? And just...
Right, right. I mean, my exploration was primarily limited to the issue of societal guilt and historical guilt. And I think it's a very, very difficult concept, and it has a lot of resonance in the Canadian context as well. How do you deal with something that, let's say, the current generation, they do not feel that they've taken a part, and yet they benefit from the results of, inadvertently or structurally? How do you approach that concept of those who can no longer have a voice, either because they're being cleansed or they're diminished or they're being killed in mass, but whose belongings and legacies through appropriation of what they left culturally, physically, and otherwise actually form the foundations of the current regime? These are very difficult questions, and I felt that a straightforward legal answer is very difficult to entertain as a solution to these kinds of questions. And that's why I went back to especially the Romans, who, some of whom really, including Epicure, had struggled with these concepts. And I have to tell you something. I mean, I'm a Mediterranean, I'm a Middle Easterner. And so the way I look at ancient Greek philosophy and Roman philosophy is not from the north. We see, especially the Eastern Mediterranean, as a lake where Northern Africa and the Middle East, everybody had a contribution to, and a lot of the texts were translated from Farsi and Arabic, right? So I don't think of it as, oh, these are ancient Greeks. I think of it as a civilizational hub. And this is what Brodel said, that's what the Black Atlantic is about. And so some of these core concepts belong to that old world of feeling that the pangs of, okay, we invaded, we raped en masse, now we built a civilization, but then that history kind of follows with you wherever you go. So they were more, I think, conceptual and philosophical inquiries on my part as to where you go.
Yeah, certainly. Thank you.
And is Dina?
Yes, and you have to excuse the online learning background noise. I just can't go anywhere. I just wanted to follow up on the conversation that was happening about like access and research, bridging research to practice. I feel like that's my cue. I know Nergis and I had an earlier meeting this day, so I was fortunate to see you twice on your birthday, but I was wearing the RN hat. I guess I'm wearing the liberal arts and professional studies hat now. And as a knowledge mobilization specialist in the Office of the Dean, I'm just thinking that I'd be happy to chat with you about like finding knowledge mobilization opportunities to circulate and like amplify the work of these two fascinating books. I mean, as a starting, like we can always like explore opportunities with the university communications team, and like, yeah, find other like a story, for example, so that people start learning about this work. So yeah, I just felt that I had to say something when there was a discussion about knowledge mobilization.
I really appreciate it. I mean, sometimes I get calls, let's say, from the Yazidi community in Canada or the Armenian community of North America. Many of these minorities who've been affected by these forced migration waves or who has been directly targeted by catastrophic ethnic cleansing, somehow they find you and then they invite you. And I always go. I remember at one point, the War Child, I think that's one of those organizations that are led by some of our students, they called me, and it was in the midst of winter, and I went downtown to Queen Street, and they had this place in a pub, and there were lots and lots of them. And when I first went in, I felt like, what am I gonna do here? And then I started talking, and then they all had so many questions. All of them were under 20. And many of them had parents who actually escaped war or survived war. And so when you go into that kind of group, that's a real social presence. They are actually the ones who are being graceful by including you among them. I mean, my own background is also tainted by war and whatnot, but not to the degree that they have witnessed it. So I feel that it's nothing similar to what you institutionally know and will hopefully guide me. But I feel that that interface personally is very important to me because this is a very socially rooted work.
Thanks. In the chat, Fatin had raised a question or a point about the need for ensuring linguistic accessibility to work, so making sure that work is translated into other languages, and says, we write on people who can't read our findings. We claim to give them voice, but they never get to validate what we write.
Mm-hmm.
I think that's a really important point to think about. It is an issue that's raised in the ethical considerations research with people in situations of forced migration, an ethical guideline that was published in Refuge, that was developed in consultation with groups that are displaced, that involve displaced people, including the Canadian Council for Refugees, and that those ethical principles essentially make the same point about the importance of establishing various accountabilities to people whose research, whose lives our research touches. Are there any other questions?
I mean, on the ethical consideration subject, we have an RRM conversation coming up. I'm working on a web archive called Ethics of Witnessing, which basically touches upon working in situations of mass human vulnerability. And I think this debate is to stay with us, and it should stay with us. So this is a really, really important debate. It's not just working with refugees or asylum seekers or forced migration, but also torture victims, war victims, cleansed populations. Well, we are forced migration experts in CRS, so like our focus is maybe more narrow, but it is wider applicability.
Any other questions? Okay, well, I guess it's left to me to say thank you again, Nergis, for talking to us today about these important books. I was very interested to hear more about the books, but I was also particularly pleased that the conversation led us into thinking about some of these ethical questions that are just so important for those of us who do research in this field. So I'm grateful that you took the time today out of your birthday to speak with us today. So thank you so much.
Thank you.
And thanks everyone for participating.